This is Brian Steele's motion, plea in bar motion to dismiss general demurrer, which was what we were talking about on Wednesday. And this is Steele's argument that the indictment is fundamentally flawed because they left out some parts of the indictment, the wording in the indictment. Renewed plea in bar motion to dismiss general demurrer. Comes now Jeffrey Williams by and through undersigned counsel and hereby files this renewed plea in bar motion to dismiss general demurrer in the above referenced case. In support of this renewed plea in bar motion to dismiss general demurrer, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all charges in the above referenced indictment. 2. On or about November 2nd, 2023, Mr. Williams timely filed a plea in bar motion to dismiss general demurrer in the above referenced case. 3. On November 27th, recused Judge Glanville entered an order denying this plea in bar motion to dismiss general demurrer. Exhibit B. 4. Mr. Williams timely requested a certificate of immediate review concerning the denial of his plea in bar. However, the recused motion was denied. Oh, where's the rest of it? Hold on. There, sorry, sharing this instead. However, the recused just denied same. 5. On November 30th, Mr. Williams filed a notice of appeal to the Honorable Court of Appeals of Georgia. And on January 7th, Mr. Williams timely filed brief of appellant with the Honorable Appellate Court. On January 19th, the Honorable Court of Appeals of Georgia issued an order dismissing Mr. Williams' appeal, finding that it lacked jurisdiction. Mr. Williams files this renewed plea in bar and asks that this Honorable Court rule on same after hearing from the parties. Mr. Williams relies upon his brief of appellate written from this Honorable Court of Appeals of Georgia, now memorialized as Exhibit C. Wherefore, Mr. Williams respectfully requests this Honorable Court to hold a hearing on this renewed plea in bar motion to dismiss general demurrer, and at the conclusion of the same, ask this Honorable Court to grant the above requested relief. So respectfully submitted. And here is the answer, which is a denial. State of Georgia v. Jeffrey Williams. Order denying defendant Williams renewed plea in bar motion to dismiss general demurrer. Upon consideration of Williams' submission, his oral argument in support, and the applicable law, this court concludes that it is bound by the controlling authority of Tate v. Jeserum v. State, Georgia Appeals from 2023, which controls on this issue adversely to defendant. Defendant's renewed plea in bar motion to dismiss is therefore denied. So that's, not much to do about that, sadly. But it was a good attempt. It was a good attempt. And this is the thing. Hold on. This is the reference in that 2023 case. In Dye, the charging instrument, like the accusation against Tate Jerusalem, alleged the defendant, quote-unquote, unlawfully possessed cocaine, and we held that, quote-unquote, unlawfully encompassed both intent and knowledge. That is the thing in Mr. Steele's motion, his argument. Those wordings, intent and knowledge, wasn't in that language. But apparently, unlawfully, which is in the indictment, encompasses both intent and knowledge, according to both die and then reassured in this 2023 case. So this is Mr. Steele's suggestion for the jury instruction that we handled earlier. Motion for jury instruction. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion for jury instruction in the above reference case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. 2. In light of the recusal of Judge Glanville, Mr. Williams respectfully requests this honorable court provide the following instruction upon the return of the juror to court for trial. Ladies and gentlemen, Judge Gerald Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. In this trial, none of the decisions of the court and nothing that any judge says is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the law I will explain to you. Yeah. Now, we heard in the beginning of this stream, this part, well, that part, the first part, that was never going to be, she would never say that. She would never say that. But there is enough in the jury instruction that she ultimately, well, is considering. There's enough there for the jury to put one and one together. Hopefully, having them not knowing why he was relieved or yeeted, that kind of makes it sound worse. Because then your imagination starts running wild. So that might actually be a good thing that she refuses to specify why Judge Glanville is gone. So that will be interesting. Court is still not